Amendment Act made in Waqf matter. What is it is all about the amendment the government passed in the parliament, sir? How do you see that?
Well, the government is entitled to bring a law, but at the same time, government is subject to scrutiny of the court. The refrain, which is now rather common, whether you hear the Vice President or you hear the Solicitor General addressing the court, in my opinion, is unwarranted. Merely because the Parliament passes a law doesn't necessarily mean that by reason of its passage, it is exempt from scrutiny and it cannot be examined for its legality. Legality is in the realm of the court, and that jurisdiction is undisputed and undeniable. So you cannot say that majority has approved it, and lakhs, and that is the argument made to the Supreme Court, that lakhs of people had supported it. That doesn't behove the government. When a government is represented in court, it will be better that it makes arguments which are legally correct and then make a case which is convincing. As far as the Waqfs are concerned, yes, there was occasion for interference and a need for reform. But under guise of reform, you cannot incorporate provisions which in some way are legally suspect. And this is exactly what the court is examining. Not dealing with the law as such, as a whole, but aspects of it which require attention. And the court is very much within its rights to do it. Even insofar as the order which the government avoided, because the order which was to be passed is now replaced by an assurance by the government, is not so much an order on the act, but an order on the effect the act will have. And as the legality is under challenge, the Chief Justice correctly mentioned that pending that challenge, any alteration cannot be done as a matter of course. So on the whole, there is a proper balance of this particular controversy, and let's see how it plays out in the next state of hearing.
So how do you stand vote?
Well, that's
correct or?
Well, that's an admission of there being something lacking in the law and a reluctance to argue the law on merits. So when a law officer of the government goes to court, it behoves the law officer to make submissions which are legally sound so as to persuade the court to hold a view which the government actually is animated by, where it brings an enactment. This shows a very defensive mindset in which there is an element of some unsureness about the legality, and it is merely a litigative tactic to avoid an adverse order. So while they can easily say that the Supreme Court has not stayed, the point is that by reason of the statement has been made by the law officer, the implementation is effectively stayed. So it's only a semantics which is different. The effect is that the act that has been brought with a lot of fanfare is for the duration it's before the court and scrutiny will not be given effect to.
So do you see the perception of Supreme Court in Waqf matter as a judicial overreach, sir?
No, absolutely not. The Supreme Court is proceeding to do what it's constitutionally obliged to do and look at the legality of an enactment. For anyone to suggest that merely because it's been passed by a large number or that there are lakhs of people who actually support it is no argument to a test of its constitutionality. A judicial review, which is a basic facet of constitutional polity and is recognized to be part of the basic structure, though of course the Vice President has got issues also with the basic structure, is by its nature anti-majoritarian. And this anti-majoritarian method is extremely important in a pluralistic society where there are conflicting points of view and there are a diverse range of interests which need to be balanced. Because there are conflicting points of view and diverse ranges that need to be balanced, you cannot simply be guided by the sheer number of people holding a particular view. Because a particular number may by default be majority. But because whoever constitutes that has to coexist with the others, and the interests of all have to be balanced. And the value which is supreme is to ensure that as far as the coexistence of competing views is concerned, that survives the conflict. The intervention of law as an anti-majoritarian measure becomes absolutely imperative. And this is what you see through a judicial process, and I feel what the Supreme Court has done and is doing is correct.